Well, good afternoon to everybody. Good to see you all again. We're going to do a workshop. We've done this workshop before, and we've been asked to do it again. It's called the Successor Trustee Workshop, and clients want to know what their trustees are supposed to do and how they're supposed to act. And so we did this workshop every couple of years or so, and we've gotten so many requests recently that we're going to do it again today. And so everybody knows how important it is to pick a good trustee, but a lot of people don't know what the responsibilities and duties of those trustees are. So we're going to talk about who to pick and what they should be doing today. So if I can get my computer to work here, there we go. So the agenda is we're going to be talking about the different types of trustees. Just like there are different types of trusts, there are different types of trustees. We're going to talk about, well, who can serve as a trustee. And then we're going to review the trustee's responsibilities as it pertains to a co-trustee, an incapacitation trustee, or a death trustee. And we'll also talk about some do's and don'ts that are important for a trustee to know. So it's important to pick a good trustee because your trustee, if we have the right person, can manage and protect the assets of the trust. That's their primary job. They also can protect the beneficiaries, not only from themselves, but also from others as well. So who are the people involved in a living trust? Well, we have the trust maker. Now that's the people who created the trust. Some people may have a trust where the trust maker is referred to as a grantor. Some people have a trust where the trust maker is referred to as a settlor. I don't like those legal terms, so I like to describe the trust maker as the person who made the trust, so we call them the trust maker. Pretty simple. The trustee are the individuals who manage the assets in the trust. It can be one or more. The successor trustee steps in when the trustee is unable to continue. And then we have the beneficiaries who end up receiving the trust assets after the last trust maker dies. So the different types of trustees, we could have a co-trustee. Sometimes clients want a son or daughter maybe to be a co-trustee to serve with them so that they can pretty much do whatever their parents could do. So if we need help with banking or finances or just taking care of business, sometimes clients want their children to be a co-trustee just to be able to help them do the things that they would ordinarily do. That's called a co-trustee. A successor trustee upon incapacity is somebody who's chosen to take care of business. If we can't manage our own affairs, we need a backup trustee if we can't do it ourselves. And then when somebody dies, we have a successor trustee upon death as well. Many times the incapacitation trustee is the same person as the death trustee. When property passes to a beneficiary of trust, we have a beneficiary trustee. Many times the beneficiary themselves, usually the children, can be their own trustee if they're capable of managing their affairs. Of course, if they're minor children, they would have to have somebody else to be the trustee until they're of age where they can manage the assets themselves. So who can be a trustee? Can anybody be a trustee? Well, you got to be over 18. You have to be an adult, and you have to be mentally competent. What about a felon? Can they be a trustee? A felon can't carry a gun, but yes, they can be a trustee. So the requirements are that you have to be an adult and mentally competent. That's about the only requirement that you have to be a trustee. So if anybody can be a trustee, who should be a trustee? Well, these are the characteristics that we think that each trustee should have when you're choosing a trustee. First of all, you want somebody who's responsible. Do you really want that irresponsible brother-in-law that you have managing your affairs? Probably not. Okay, so we want to pick somebody who's responsible. Do we want We also want somebody that you have confidence in. Do you trust that person? Has that person that you're choosing as a trustee, have they ever lied to you? Have they ever stolen anything from you? Well, if they have, maybe that's not the person that you want, because you want somebody who's trustworthy. You also want somebody who can make decisions. There's nothing worse than having a trustee who can't decide whether to do this or that, and they just can't make a decision. So you have to have somebody who's not indecisive. If you don't have anybody that you want to serve as trustee that has these characteristics, it might be advisable to maybe hire a professional trustee. And yes, that does cost some money, but if you don't have anybody else, then they can be a valuable asset to make sure that the trust is being conducted properly. So these are characteristics I just mentioned that are desirable. The trustee also has fiduciary responsibilities that are mandatory. The law says that these trustees must have these duties. We have to have the duty of impartiality. We can't say that, well, I'm going to treat these individuals differently because Susie is just so cute. I want to give her more and I want to take care of her differently than the others. No. Can't do that. You have to treat everybody equally. You have to have a duty of loyalty. You can't do things that are against the interest of the trust maker. You have to disclose adverse interests as well. You have to disclose all relevant facts. You can't hold things back. You can't say, well, I'm just not going to tell the other beneficiaries or the trust maker. I'm just not going to tell the people involved in this trust these facts because, I don't think it really makes any difference. I don't think it's going to help things. Well, that's not the rule. The rule is that if you have any relevant facts, regardless of whether you think they're important or not, you have a duty to disclose all the facts to the relevant parties. So you don't have a choice in that. So if a successor trustee is going to take over in the case of disability or incapacity, how do we know that the trust maker is incapacitated? Well, usually the trust document itself is going to define what disability is. And usually one of our trusts is going to have a definition that says essentially that if you get a letter from two doctors that says that this person is unable to take care of their business or financial affairs, then they're disabled or they're incapacitated. Okay. Or usually if you have an unexplained disappearance or absence, you're just gone for 30 days and nobody's heard from you, then you can be declared to be incapacitated. Or if you're incarcerated or in prison, or if you're kidnapped, you can also be incapacitated. But if you are incapacitated, then a certificate of trust will be issued that identifies who the successor trustee and really appoints them as the trustee. If a trustee is going to serve after you, then you need to make sure that they have the appropriate documents, because they need a HIPAA authorization, they need a power of attorney, a healthcare power of attorney, and the living will, because they may need to get information from a doctor to determine if you're incapacitated or not. Doctors won't talk to you unless they have a HIPAA authorization. The successor trustee also needs to become familiar with the finances. You need to know what's going on financially with the trust. If you can't do that by yourself, then you need to seek professional help. Usually the trust is always going to provide that people can be hired to help and assist with help getting financial information or other aids. We can pay for professional help. So let's take a look at the incapacity checklist. What should we do if someone is incapacitated? First thing we need to do is we need to confirm that all assets are in the trust, because the trustee manages assets that are in the trust. If they're not in the trust, then the trustee doesn't have any control over that. If we need to get the assets into the trust, you have a power of attorney that would allow the trustee to put those assets into the trust for you if you can't do it yourself. The trustee needs to continue to pay bills, taxes, and expenses And you want to make sure the utilities are still on. We don't want the air conditioning going out in summertime. We want to make sure that all the bills are paid. And we also want to remove the current trustee from any financial accounts. If you have somebody who's incapacitated, mom is incapacitated, we certainly don't want her in charge of the checkbook, because she may be writing checks to someone that maybe she shouldn't be writing checks to, and maybe she doesn't know that. So we definitely want to get incapacitated people off of the signature cards and not be able to sign checks and pay bills. So the trustee can also oversee the care of that incapacitated person. And if there's any business that needs to be taken care of, that's the job of the trustee. And one of the most important things that they need to do is they need to surround themselves with advisors. They need to contact a lawyer, a CPA, financial advisor. They need to make sure that they can do all these things with the help of the people that can help them. They also need to keep accurate records. If you don't keep accurate records, it could come back and harm you later on when you're trying to get reimbursed for some of the expenses that you incurred. If you can't show that you actually made these expenses, then you're not going to be able to get reimbursed. So it's important to keep very accurate records. So then upon death, here's some of the trustee administration duties. One of the first things that I want to talk about is that the trustee must follow the terms of the trust. And this is true even if you are a trust maker. So if you're married, you have a joint trust, one of the spouses died, then the surviving trust maker has some things that they need to do according to the terms of the trust, and they need to follow the terms of the trust. If we've had situations where a spouse would die and then the other spouse just didn't do anything, and years go by and then we have problems down the road. And we really have problems if the surviving spouse dies and things that should have been done were never done. So that's a problem. The trustee upon death also gathers all the assets together and then they pay all the legitimate debts. And after the legitimate debts are paid, which includes taxes and expenses, then we distribute what's supposed to go to the beneficiaries to them. Now, the trustee has an obligation to gather assets and pay legitimate debts. Well, what if they don't pay those debts? Well, guess who's responsible and legally liable for paying the debts? If we have assets that could have paid the debts, then we didn't pay the debts, the trustee is personally liable. So it's very important that we make sure that all the assets are gathered, we pay all the legitimate debts, and then we make the distributions. So what are the successor trustees' responsibilities? The first thing they need to do is they need to read the trust. I can't tell you how many clients we've had that have come in as a successor trustee and they haven't read the trust. They don't know what the trust says. So I know some of these documents are long, but you need to read the trust to see what it says and see what your responsibilities are. You also should read the trust to see what your powers are and see what you can and can't do. You should not mix trust assets with trustees' assets. We've had clients who've taken charge of mom's trust account, and they've taken money and they put it in their own bank account. Well, we're going to keep it for safekeeping, so I'm going to be in charge of it, so I'll just put it in my bank account. No, you can't do that. You can't mix trust assets with your assets. You can't use trust assets for your own benefit. If you're the trustee, you can't use the trust assets. So if there's a car involved, the trustee should not be driving that car. It's a liability, and they're using assets for their own personal use. So they should not do that. Like I said before, you need to treat all the beneficiaries the same. I know Susie's cute. I know she's just sweet. We've always liked her, but just because you like one beneficiary more than the other, you have to treat them the same. The trust assets must be invested in a prudent manner. Your brother-in-law may have this great investment opportunity that somebody told him about, and he thinks you ought to invest in that. Well, no, you better check it out. You better check out and be a prudent investor. And once again, keep those accurate records. So here are some to-do lists for successor trustees. Here's some things that we need to keep in mind that they need to do. And this becomes a problem sometimes when we have several children who are the beneficiaries, and one of them is the trustee. You have to establish your authority as trustee. I know the siblings look at that, look at each other as equals. They don't think one child should have any more authority than the other, but one child is chosen as the trustee. Well, they have certain responsibilities and duties that the other children don't have. And so they have to establish their authority, because if something goes wrong, that particular child who's the trustee is the one that's going to be liable and responsible. So they need to say, I know we're all equal as children, but as far as this trust goes, I have to be in charge because I'm responsible for it. We need to determine the nature and the value of all the assets, and we need to take control of everything. We need to set up proper accounting procedures. That may be requiring hiring a CPA to help us, or a bookkeeper, to make sure that everything is being accounted properly. We need to establish communications with the creditors and with the beneficiaries as soon as possible. Now, the reason for that is because the general rule is for beneficiaries, if they haven't heard from the trustee within a period of time, their assumption is they're not doing anything. And that may not be the truth. The trustee may be working very hard, but if they don't communicate that to the beneficiaries are going to be thinking that they're not doing anything. So even if nothing's going on or not much is happening, contact the beneficiary and say, you know, we're working on this case. We've got some things to do. Nothing's going on right now, but I'll let you know as soon as something happens, just to make sure that they know that you're involved and you're keeping them involved. If there's any disputes, you definitely want to resolve those as soon as possible. Nothing worse than having a dispute escalate and escalate and escalate until you really have a war going on later on because we didn't settle things at the beginning. And then also, you want to carefully follow the trust's directives. If the trust says you need to do some things, then you need to do them. We had a client once that the mother-in-law died, and the wife of the daughter was the trustee, and she brought her husband in to talk about what was needing to be done. We told her what needed to be done, and you know what the husband said? He said, "We're not doing that. We're not going to do that. Forget it." Well, what are you going to do? I mean, the trust calls for you to do certain things, and she's got her husband saying, "We're not doing that." Well, you know, it could lead to very serious problems if you don't follow the trust directives. So that's very important. You want to make sure that you do follow those directives. Some things not to do. Well, you don't want to sell or distribute assets until you see an attorney. I mean, we've seen clients start giving things away before they even become the trustee. And if you start giving away assets, because I know mom wanted to give Susie $100,000. Well, we'll go ahead and give it to her now, get that settled. And Tommy was going to get $10,000. We'll go ahead and give him that now. Well, if you start giving away assets, you don't even have authority to give anything away. So you can't legally do that. But if you do that, and you end up in a situation where you don't have enough money to pay the debts or the taxes, you're personally responsible for it. You don't want to engage in self-dealing. You can't be buying things for the trust without authority. So you don't want to be dealing things on your own, loaning yourself money. I'm a trustee, and mom had all this money in this trust, but I got bills to pay, and I can't pay them myself. She's never going to miss this. The others aren't going to miss this. And I'll pay it back. No, you cannot do that. You can't loan yourself money. You can't take money out of the trust for your own benefit. So don't allow any conflict of interest to exist. Don't keep those poor records. Make sure you account for everything. And then don't fail to communicate with the beneficiaries. Like I said, if they haven't heard from you, then you're not doing anything. Don't allow disagreements to be unresolved. Get those things open and out in the front at the very beginning. Don't act independently of the trust directives. Yeah, I know Dad said that he wanted the money to be used for this purpose, but I don't want to do that. I want to do something else with the money. No, don't do that, because you're going to cause problems with the other beneficiaries and you may get yourself sued. Don't take unreasonable compensation. We had a client that died, and his trustee took over, and she was charging $200 an hour to clean out his garage. Now that's an unreasonable compensation. Well, she got sued for it and she had to pay it back. So be careful about thinking that, well, I'm in charge of the money, I can charge whatever I want to. No, usually the trust is going to provide that you can be paid, a trustee can be paid a reasonable compensation. And we use that term reasonably because it's going to depend on the circumstances of each case. But $200 for cleaning out a garage is not going to be reasonable. So the question is, if I'm a trustee, do I have to do all this stuff myself? No, the trustee can get professional help. They can hire the CPA. They can hire an attorney. They can hire a financial advisor. But even though they hire these people, they need to understand that ultimately it's the trustee who's going to be responsible. So here's some common mistakes that successor trustees make that we see. The successor trustee comes in and they don't know what assets are in the trust, and they just start guessing. They have no clue, and they're not taking the time to find out what assets are there. So it's important that the successor trustee seeks the advice of an attorney who can look at the document and tell exactly what needs to be done. And if we have to get an inventory, then we can get an inventory. What values are we going to use in the inventory? Do we use the value that, well, we bought this thing 5 years ago and I think it's worth about this much? No, we have to use the valuation as of the date of death. And so there's certain rules that we have to go by. And if the successor trustee doesn't know those rules, then they need to find out what they are. The successor trustee believes that they're the trustee without consulting an attorney, without obtaining the necessary legal documentation. You know, somebody is named as a trustee, son or daughter is named as a trustee, they think they're the trustee. Well, no, they're named in the document as trustee, but they haven't become the trustee. There's certain documents, either called a certification of trust or an affidavit of trust, that legally appoints that individual as a trustee. So they can take that document to the bank or to the brokerage firm or whoever else they're dealing with, and they can actually prove that they are the successor trustee. Just because their name is in the document doesn't make them a trustee. Another problem that people make is that they give in to outside pressure from the beneficiaries not to follow the terms of the trust. And then we see this all the time. We recommend that when somebody inherits property, they inherit it in trust. Now, if we get it in trust, that means that our creditors can't get it. If we get a divorce, our ex-spouse can't get it. If we file bankruptcy, the bankruptcy court can't get it. So it's going to be asset protected. But you know, we've got clients that had children that they say, we don't want it in trust. We just want the money. We don't want to bother with a trust. We're not going to lose it. Just give it to us in trust. And then the trustees under the pressure because their sibling wants the money outright. What do? Do we give it to them outright? Well, you could, but you're not following the terms of the trust. So if you give it to them outright and then something happens, they have that car accident, it's their fault, they get sued, there's a judgment taken, and now the judgment creditor takes the inheritance away from the beneficiary. That beneficiary might come back to the trustee and say, you know, that trust that was set up, wasn't there a provision that would have protected me so that my creditors couldn't get those assets? And the trustee's going to say, yeah, but you wanted the money outright. Well, the beneficiary might say, yeah, but you were obligated to follow the terms of the trust. So lawsuits have taken place over that situation, and you don't want to be faced with having to pay somebody's damages because you gave it to them incorrectly. So what if you've named co-trustees? Sometimes people will name their children as a co-trustee. Jane and John can serve together as co-trustees, right? Well, the question is, can they really serve together? Can they act together? Do they get along? If they don't get along, if they can't agree on anything, then maybe you're starting World War III. You don't want to have a situation where the trustees are fighting and nothing gets done. So can they act independently? Well, that's going to depend on the document. You have to look at the document and see, because it will state in the document whether or not they can act independently or not. They need to know also that neither one of them has more decision-making power than the other one. You need to make sure that they know that. I know Johnny is older than Jane. I know he's the big brother, but he doesn't have any more power than she does, and they need to know that. So what happens if you breach that fiduciary duty? Well, one thing that can happen is you can be removed as trustee. You can also be sued for violating your fiduciary duty. In certain circumstances, there might be some criminal penalties involved. So you definitely don't want to violate your fiduciary duty. So think about the trustees that you've named, and you might want to make sure that one, they meet all the characteristics that you want a trustee to have, and two, if they're going to serve as trustee, will they follow the rules? Will they do what they're supposed to do, and will they act accordingly? We have many times we change trusts just to change the trustees because we've determined that, well, really, the person that we named probably is not the best person. And sometimes it's the only person you have at the time, but sometimes other people come along in your life who maybe that are better suitable. If that happens, it's simple to do an amendment. You can amend trustees out as long as you're competent and alive and capable. You can do that. Don't wait until you're incompetent. Once you're incapacitated, then the trust might become irrevocable, unchangeable, and you might not be able to change those things. So if you think that you might not have the right people involved, maybe it's time to revisit that trust and take a look at it. So if you're unsure, if your trustee's unsure about what their duties and responsibilities are, we've got an in-depth instruction guide for trustees. We charge our costs, it's $195, but it tells them exactly what their duties and responsibilities and what they need to be concerned with and what they need to do a good job. So the successor trustee is an extremely important position. And unfortunately, many times people will set up a trust and appoint people as a successor trustee, usually it's their children, and they don't even tell them that they're the trustee. And so the first time that the individual finds out that they're a trustee is when something happens to mom or dad. And maybe that's not the best time to do it because they may not even want to serve. If they don't want to serve, then we've got other problems. So if you have other questions about this or anything else, you can check out our website. We've got some free books that you can download. Marcy's written several books on elder law that you can look at. I've written some books on estate planning, and feel free to go on our website and you can download those books for free. So I'm going to open it up for questions now because we basically covered some do's and don'ts and some things that we need to be concerned about. I'm also going to ask Joanne, who does most of our administrations when somebody dies and has to deal with successor trustees a lot and knows some of the other problems that we've had to face with dealing with trustees who are either uneducated or unwilling to follow the rules. Joanne, do you have any comments about any of the things that we talked about?
Well, thank you, Richard. What I see on a daily basis is the fact that teaching a successor trustee what their responsibilities are and what the trust says seems to automatically fall on our shoulders versus the trust makers helping us prematurely educate their appointed successor trustees. And I think if we try and educate these successor trustees ahead of time, maybe they won't remember, but everything we talk to them about at a time of crisis, or the fact that we're dealing with a death, they really don't comprehend their responsibilities. And it takes us a long time to get them educated enough to take on the responsibilities that the clients have put on these successor trustees. So I think sharing and educating now will better suit the beneficiaries later.
Good. Does anybody have any questions about any of the topics that we talked about?
If you do have a question, you can unmute yourself and ask your question. And let's try to do it to where we don't interrupt everybody at the same time. And you should have an unmute button at your lower right-hand corner or lower left-hand corner.
I have a question.
Hi, Catherine.
Okay, so if Bill dies and that, does that mean I'm the successor trustee and I still have to do all of this stuff?
Generally, yes. Well, it depends on your trust. Your trust, yes. You're both trustees.
Yeah.
And if one of you dies, generally speaking, the surviving spouse is going to be the trustee.
Well, that's what ours says. So, but we still have to go and get the legal documentation that I'm the trustee and all that stuff.
Well, it's going to depend on the circumstances. You may or may not have to, but you're probably going to get the assets under your control solely and not have Bill's name on it. So you probably would get a certificate of trust, which is real simple to do, and you can be in charge of everything. So, but you are a trustee right now. You're both
Right.
trustees.
And
You're
all
both trustees.
of our assets are in the trust
Good.
now.
That's another thing. Good point, Catherine. If you need to look at your assets, and you need to determine that all of your assets that are supposed to go into the trust are in the trust, because a lot of people don't realize this, but if you die and the assets are not in the trust, if they don't have a way to get into the trust, like if they don't have the named beneficiary, or I mean, some assets are not in the trust. Your IRAs, your retirement accounts, they're not in the trust because they have a named beneficiary. Okay, they're going to go automatically. But if you just have something in your name that's not in the trust, it's likely to have to go through probate. And that's one of the things that we were trying to avoid when we set up this trust in the first place, is to have assets passed to our beneficiaries outside of probate. But the trustee is going to have to now take that will and take it to court and have the assets probated back into the trust, and then they'll manage things in the trust that way. So it's very important that you double check, because invariably we have clients that think they have everything in the trust, and somebody dies, and then we find some asset that never made it to the trust. So you just want to, you can't do this too often. Take a look at your assets. You just make sure that whatever you have, and some people don't know. Some people have some property that they don't know if they put that in the trust or not. Well, you can check the deed or check the deed records and find out who the owner of that is. And it's important to do that, because you don't want to hope that everything's been done right. You want to make sure it's been done right.
Richard,
Yes.
don't shock me.
Hi, Joseph.
Hi, quick question. What is the specific documentation, legal documentation, that is required to provide to banks, et cetera, to indicate who the successor trustee is?
Well, the legal document is a certificate of trust. Now, what the banks and brokerage firms are going to want in addition to that is what's called the privacy affidavit section of your portfolio. So if you've created your trust within the last, I don't know, 15 years or so, you're going to have a section, or probably more than that, 20 years. you're gonna have a section called privacy affidavit. And in that privacy affidavit, there is a certificate of trust, an affidavit of trust. There are certain portions of the trust document. You'll have the first page of the trust, which says that you created a trust. You'll have the section that identifies the trustees and the successor trustees. And you'll have a section that identifies the powers of a trustee. And then you'll have the signature pages of the trust. We're not going to tell the bank how much money you left Johnny, or how much money you left Susie, or the fact that you cut out Billy. We're not going to tell them any of that information, but we are going to tell them what the fact that you have a trust, that who the trustees are, what they can do, and the fact that it's a legal document. So that's what they need, and that's what they'll keep on file. So you can take that privacy affidavit to the bank and let them copy that, put it back in your book, and then you're set.
Richard, may I state, Mr. Shockney, it's going to, the banks are going to want proof of death. We can't just create these documents replacing a trustee with another trustee without some type of legal document. In the event of a death, we would need to show proof of death with the death certificate. In some cases, the trust changes form, and that person who is deceased, they lose their social security number that is attached to their trust. And there may be a potential there for us to have to get a tax ID number. So every circumstance is going to require other documents outside of the trust. And that is something that we will help you with, or your trustees, when it comes that time.
If the book could go to them.
Thank you.
Thank you.
We have a question. Why can't you separate and pay all the beneficiaries out and dissolve the trust?
Well, it's going to depend on what the trust says. Now, sometimes the trust will say, when I die, I want the assets, I want the bills to be paid, the taxes to be paid, and whatever's left over, I want to pass it to these beneficiaries outright. It's theirs. They can do anything they want to with it. We're not going to keep it in trust. It's just theirs. And then, yes, we can pass it outright. But if the trust provides that it goes to those beneficiaries in trust, then we have to follow the terms of the trust. Now, generally speaking, if somebody inherits property and they get it in a trust and they just say, you know, I don't care about the asset protection. I don't care. I'm not going to get divorced. I'm not going to file bankruptcy. I'm not going to lose these assets. I don't want the property in the trust. Well, if that's the case, generally that person is going to be in charge. They're going to be the trustee of their own share. And so if they withdraw the funds from that trust, they can do that. They take the money out of the trust, and then they can do whatever they want to with it. Unfortunately, it is exposed. It's not going to go to the people that the trust makers wanted it to go to, because when mom and dad set this trust up, they wanted it to go to our children. But if our children died before they got the money, we wanted it to go to our grandchildren. We didn't want it to go to our in-laws, okay? But it'll end up going wherever that child wanted to go if they take it out of the trust. That's why we keep it in trust, because mom and dad wanted it to go a certain way, and we're trying to honor their decisions by making sure we follow the terms of the trust. And once the trustee has done, and so we've had situations like that where somebody wanted the money, they did not want it in trust, and we had a trustee that said, "What do I do? They want it outright. Can I give it to them outright?" So we said, "No. What we're going to do is we're going to follow the terms of the trust, and we're going to give it to them in trust." Now, once they get it in trust, if they want to take it out, that's fine. They can take it out and just stick it in their bank account and hope nothing happens. That's fine with us. But you, Mr. Trustee, have done exactly what the trust called for you to do. And so if they lose it later on, they can't come back and sue you saying you didn't do your job, because you did exactly what the trust called for you to do.
Okay, I have a question.
All right.
Can you hear me?
Yes, I can.
Okay, yes. I'm in the process, my father's gone into assisted living, and I'm in the process of selling his home. And the title company emailed me the other day saying that they needed a copy of the trust. And I asked, well, do you need a certificate of the trust? And they said, no, we need the entire trust. Do they get the right to copy that entire trust?
You know, that's going to be up to you. What they're entitled to is what I just told you under that privacy affidavit.
I'm
Now,
sorry.
what they're entitled to is what I told you about in that privacy affidavit. They can get that information. We have had certain companies and institutions say we want a copy of the entire trust. Okay, so your option is to say, no, you're not getting the entire trust and I'll just go elsewhere. Or if you want to give in to them and say, you know, I don't mind you having that information. You're not really entitled to that information, but I'll give it to you just to make things easier. You can do that. You're not obligated to do it, but you can do it just to make things easier. So that's going to be your call as to whether or not you give them that information or not.
Okay.
But if you have a situation where dad is in a special needs facility or a nursing home or a care facility, and you're getting ready to sell the house, you might want to have a conversation with our office to determine if that person might be entitled to some government benefits. Maybe not, but they might be. And selling the house could be a hindering factor in getting some of those benefits if it's not done correctly. So before you sell the house, you might want to check with our office, let us see your situation and see if there might be some benefits coming their way.
Okay, well, there's a contract on it now, but it's not to sell till around August 1st.
But once again, you need to know what your options are. So I would definitely find out because selling the house could eliminate some of the options that you have.
Okay, so I'll call and ask them.
Okay. Anybody else have a question?
Hello, can you hear me?
Yes, Mary.
Yes, I didn't get that website where the free manuals were. Was that?
Oh, let me go back. How's that? Can you see that?
Okay, I got the WW Johnson firm, but I didn't get the PC.com. I knew it was .com. Okay, PC.com. Oh, and one other question, because I'd like to read those manuals, yeah, if they're free. My sister's the successor trustee, I guess, and I'm glad. But here's what I was wondering. I was noticing you said that you have, it's a good idea, you must read the trust. Now, if I'm next in line, do I need to read that trust now, or is it important, or how important is it, or how would I do that even? Because those are big, thick books in y'all's office, right?
Well, if you're getting ready to serve as trustee, you need to read the trust. If you're a backup trustee and you're not going to serve anytime soon, you know, it's not that important because you're not set up to be acting immediately. But if you're on deck and you're ready to go to be the next trustee, and you're going to be serving as trustee, then yes, you do need to read the document.
Then I would come in and maybe look at it. Okay, yes, sir. I just didn't want something to happen 6 months down the road and then, oh, I should have read it already because I don't really want to. Okay, thank you. That's all.
Well, yes, it is a long document. So what we recommend that you do is if you want to find out what your rights and duties and responsibilities are, make an appointment, come in and we'll go over with you. And
well, that would be later. I'm hoping it'll be Susie always. Okay, thank you. Thank you.
Okay.
Yeah. Okay.
Anybody else?
I'll ask a question. Can you hear me?
Sure, Bart.
Is it an oversimplification to say that if I were to sum up this whole meeting, that probably the most prudent thing to do would be to contact your firm if you become a successor trustee for some general guidance on the first steps and making sure things are done right?
That's a good summation.
All right.
But I could have saved a lot of time, couldn't I?
No, and I realize your book probably would help too, and certainly this is a big assistance. But it just sounds like some of the legal documents that need to be filed and some of the hurdles that need to be jumped through. It just seems like you would be a first stop at the minimum.
Well, you know what? It does not have to be difficult. but just knowing what's expected of you and knowing what the roadmap is would help. And like I said, it does not have to be hard, but there is a protocol. And unfortunately, in the past, there were trust salesmen that said, if you do a living trust, that's all you'll ever have to do, and you don't have to do anything else. But what they don't realize is that both trust and wills have rules. If you have a will, the rules are contained in the Texas probate code, and you file the will and probate, and you go through all the ramifications that a judge oversees everything and makes sure the property gets to the right people in probate court. Well, trusts have similar rules. It's covered under the Texas Trust Code. And you do have to jump through some hoops, but you don't have to do it in the courthouse. That's the beauty of it. Okay, so it's done privately and usually with family members that are going to be more friendly and easier to deal with, hopefully. That's the idea behind it. So, but there are things you have to do. So if somebody says, well, do this, you never have to do anything, that's just incorrect.
Great. Thank you.
Well, I would like to say one thing, that we noticed that successor trustees seem to be overwhelmed with the responsibility, and there's a lot of legal language that scares them. And when they hear that they have a fiduciary responsibility and they have to work with all the beneficiaries, it's a little overwhelming. And one of our jobs is to help walk you through the processes step by step, help you understand what the responsibility is and what you do next. So I try really hard to help the successor trustees understand their responsibilities in a slow motion, instead of here's the trust book, go find the assets and call me later. We walk you through every single step. You're never alone when you contact an attorney to help you go through administration or the replacement of a trust maker as a successor trustee under disability. We will help you understand what you need to do.
Anybody else have a question? Well, I hope you all know that if you do have questions, you can call our office and we will talk to you and we'll try to answer your questions. So if you have a question, feel free to give us a call at the office and we'll be glad to get back to you and answer any questions. So I hope today has been helpful for you. I think it's important to go over this periodically. I know we've done these workshops in the past, but nevertheless, you don't always have to be told, but you need to be reminded. And so this is a reminder that yes, there are responsibilities and duties, nothing to be afraid of, but you just need to be aware of what's expected of you and what we're looking for as a trustee. So if thinking about all the things we talked about, think about who you have named as your backup trustees. And you want to make sure that they meet the qualifications and the characteristics that we talked about. If they do, wonderful. If they don't, then let's look at some alternatives. And if you don't have any alternatives, we may have some suggestions for you that you can take into account. But I think that having the wrong trustee can be problems down the road for the beneficiaries, and it's just unnecessary. So we don't want to make things harder. The reason why you did this plan in the first place was to make things easier. So you certainly don't want to make it harder by having the wrong people involved. So I want to thank each one of you for participating in this. And once again, if you have any other questions, let us know. We're doing other workshops on different subjects from time to time. So hopefully we'll send you an email if we're doing a workshop that might be of interest to you. But if you have a question about whether or not somebody might qualify for government benefits, either veterans benefits or Medicaid benefits, Marcy works heavily in that area. And she's written several books on our website about that, about who can qualify and what do you need to look for in qualifications. So if you want to just be educated on those subjects, then feel free to download those books. It may not be anything important now, but it may be something later on, or you may know someone who falls into that category. Most everyone knows a veteran, And there's a lot of veterans benefits out there that the Veterans Administration is not telling their veterans. They're just not telling them. And so, but there are benefits available if they qualify. So there's ways to get them qualified, and we can help you do that. So hopefully this has been beneficial to you. And I wish everyone a wonderful summer, and let us know if there's anything we can do to help you in the future.
Thank you.
Thank you very much.
Thank you.
Thank you.